Folks, we've got some huge breaking news in the James Comey federal criminal case. And when I read this order to you, when I tell you as a trial lawyer and a former criminal prosecutor for, decades, I'm stunned with what I am reading. Folks, when we knew that Lindsay Halligan, insurance lawyer, was being invalidly appointed as the U.S. attorney in the Eastern District of Virginia simply because she is Donald Trump's personal lawyer and he wants one of his law lackeys to prosecute his political enemy. When we knew that happened, we knew it was going to be a bad result. And we were relieved when we knew that James Comey brought on board such an exceptional criminal defense team. But even the judge in this case, who has been appointed by the presiding judge, this judge who has been appointed to be able to look at irregularities and to handle some issues concerning the grand jury materials, this judge has entered the most scathing 24-page order that I have read in my professional career. And this is not hyperbole. This is not melodrama. I am going to walk through this order with you because I want you to understand how much this order reflects not only the irregularities, the illegality, and the stupidity of the Trump administration's Department of Justice, headed up by Pamela Jo Bondi, when it is pursuing these ridiculously illegal, vindictive, and selective prosecutions of Trump's political enemies. Let's get into it. It is critical for us to walk through this. Bear with me, because when I walk through it with you, you're going to understand why I'm having this incredible reaction. I am going to start with the end, and then we're going to fill in the reasoning behind this judge's ruling. This judge is William Fitzpatrick. He is a federal magistrate judge. Let's take a second to talk about procedures. There are district court judges. They are the trial judges in federal court, and they reside in, or they work in, a particular district of the United States. In this instance, the magistrate judge is the judge who's assigned to that district court judge to handle discovery issues and other motions that are pending. Kind of like the backup quarterback, as we would call it. Now, what's interesting is magistrate judges, their findings and recommendations, their rulings can be appealed to the district court judge, kind of like in a mini appellate procedure. In this instance, the presiding judge, Judge Nachmanoff, said that he wanted Judge Fitzpatrick, the magistrate judge, to be assigned to deal with some of the stuff that has arisen in James Comey's prosecution. So, Judge Fitzpatrick, no relationship to James Comey's lawyer, Pat Fitzgerald, entered this order. And I want to read the findings to you because they're very important. And the findings by the court begin on page 20 of 24. Based on the foregoing, which you and I will get into in just a minute, the court makes the following findings. First, the facts establish a reasonable basis for the defense to challenge whether the Richmond warrants were executed in a manner consistent with the Fourth Amendment and the orders of the issuing court. Second, the facts establish a reasonable basis for the defense to challenge whether the government exceeded the scope of those Richmond warrants in 2019 and 2020 by seizing and preserving information that was beyond the scope of those warrants. That is, the information did not constitute evidence of violations of either two federal statutes, which are the ones that James Comey has been charged with in the indictment that was obtained. Third, the facts establish a reasonable basis for the defense to challenge whether the government had the lawful authority to search those Richmond materials in a new way this year in 2025. Fourth, the facts establish a reasonable basis for the defense to challenge whether the government's 2025 seizure of the Richmond materials included information beyond the scope of the original warrants. Fifth, the nature and circumstances surrounding the government's potential violations of the Fourth Amendment and court orders establish a reasonable basis to question whether the government's conduct was willful or in reckless disregard of the law. Sixth, the facts provide a reasonable basis for the defense to show that they were prejudiced by the government's use of those materials in the grand jury, particularly if the government's conduct was willful or reckless, given that those materials were central in the government's presentation to the grand jury. Seventh, the facts establish a reasonable basis that defense can challenge whether the government took sufficient steps to avoid the collection and review of privileged materials. Why? Because James Comey's lawyer was Mr. Richmond at the time that those materials were seized from Mr. Richmond, including the reasons why was James Comey not given the opportunity to assert a privilege over his communications with his lawyer. Eighth, the facts establish that there's a reasonable basis for the defense to challenge whether that privileged information that was illegally obtained was used either directly or indirectly by the government to prepare and present its presentation to the grand jury. Quote, this is particularly troublesome because the government's sole witness during that grand jury presentation was exposed to a limited overview of that privileged material that was privileged between Comey and his lawyer Richmond shortly before that agent testified. Ninth, the nature and circumstances surrounding the disclosure of potentially privileged information establishes a reasonable basis to question whether the government's conduct was willful or in reckless disregard of the law. Particularly because that agent who made that grand jury presentation, after having been exposed to potentially privileged information, chose to testify before the grand jury rather than separate himself from that investigation in order to contain or to hold in any further exposure to privileged information and to limit any prejudice to James Comey. 10th, as discussed above, the prosecutor made statements. The prosecutor, Lindsay Halligan, made statements to the grand jurors that could reasonably form a basis for the defense to challenge whether the grand jury proceedings were, quote, infected with constitutional error. And 11th, the grand jury transcript and recording likely do not reflect the full proceedings because although it's clear that a second indictment was prepared and presented to the grand jury, the transcript and the audio recording do not reflect further communications with the grand jury after it began deliberating on that first indictment, meaning there's a serious disconnect between what that transcript and proceedings actually represent. People, these 11 findings by Judge Fitzpatrick have prepared and created the grounds for the judge to order all of the grand jury materials to be turned over to James Comey's defense team. When I tell you that this is truly, it doesn't happen. Grand jury materials remain confidential. The law and the rules of procedure militate towards keeping these things confidential. But this judge has found so much bad shit has happened because of Lindsay Halligan that this judge says, you know what, James Comey, your criminal defense team gets all of it and then some. Alrighty, so now that you guys know what the findings were, let's fill in some of the blanks that you must have as to what is this judge actually thinking about, because when I tell it to you, you're going to fall out of your chair. Here we go. The court had to decide a narrow issue of whether there are particularized and factually based grounds to justify the disclosure of grand jury materials pursuant to a specific rule of criminal procedure that governs whether confidential grand jury proceedings and records can be turned over, and in very limited circumstances, they can be. The court finds that this extraordinary remedy that is rarely granted shall be done so in James Comey's case. And here is why. Okay. It's important for you to know the law. The law begins on page 3. The long-established law is the following. Policy is to maintain the secrecy of grand jury proceedings as codified in Federal Rule of Criminal Procedure 6, subsection E. However, as I just stated a couple of minutes ago, Rule 6, subsection E provides for several exceptions under which a court may authorize disclosure of grand jury materials. If the court finds, that there are particularized needs that have been set forth by a criminal defendant to obtain these grand jury materials, then a court may order the disclosure of otherwise confidential grand jury materials. The Fourth Circuit Court of Appeals, which is the federal appeals court that governs everything that is happening right now in James Comey's case in the Eastern District of Virginia, has held that this particularized need inquiry requires the trial court to balance the petitioner, as in James Comey's need for this material, okay, against whether we need to keep them confidential. And only will that need by the criminal defendant like James Comey outweigh the public's interest in keeping it secret, only when there's a particularized need expressed for the release of those materials. And the rule is very clear. This is not an invitation to engage in a fishing expedition. The grand jury proceedings, because they are entitled to a strong presumption of secrecy, it means a criminal defendant bears a heavy burden to show that these particularized and factually based grounds exist to support the release of these materials. So can you imagine, folks, that a judge has found that James Comey has met not only this heavy burden, but has found such a level of irregularity in the conduct of Halligan in obtaining this indictment that Comey is entitled to all of these grand jury records? So what exactly are we talking about that were the Richmond warrants that the judge mentions in his factual findings? Well, let's take a little bit of a trip back in history so you understand and you have a good foundational factual basis for appreciating this order. In 2017, the U.S. Attorney's Office for the District of Columbia initiated an investigation that had been referred to the FBI, and the name of that investigation is called Arctic Haze. Remember that, Arctic Haze. The investigation was concerning an allegation that there had been unauthorized disclosure of classified information to a New York Times reporter, which appeared in an April 2017 article entitled, quote, Comey tried to shield the FBI from politics, then he shaped an election. Daniel Richman. Okay, so this is why we talked about them being called the Richmond warrants. Daniel Richman, a Columbia Law School professor, a personal friend of James Comey, and former special government employee at the FBI when James Comey was the FBI director. Daniel Richman was quoted by name in that New York Times article, and Richmond was the subject of the U.S. Attorney's Office, D.C.'s investigation. I'm going to stop here because this is critically important for the analysis in this order from the judge. Daniel Richmond was the subject of that criminal investigation that gave rise to 4 search warrants that were used to obtain information and materials from Daniel Richmond. Keep that in mind, okay? So remember, this was a 2017 investigation. Fast forward to 2019 and 2020. The FBI got 4 search warrants authorizing its agents to search a hard drive, an iCloud account, an iPad, and an iPhone belonging to Daniel Richmond, as well as 2 of his Columbia University email accounts that were used by him. So these are now being referred to as the Richmond warrants. And that's the language that the Judge Fitzpatrick used. The Richmond warrants authorized these FBI agents to search for and seize information that was created or stored between the following dates: March 1st, 2016 and May 30th of 2017. And the specific crimes that were set forth in the search warrants, and this is the law, people. When you get a search warrant, you're required to identify the crimes about which you were doing the searches and seizures. It's only fair, right? That's what the law requires. There were 2 alleged violations that Mr. Richmond had done. One was theft and conversion of stolen government property, and the second was unlawful gathering or transmission of national defense information. Okay. 4 search warrants, they're called the Richmond warrants. They were to search certain things: iPad, iPhone, email accounts, iCloud, hard drive, and it was only between March 1st, 2016 and May 30th of 2017 concerning 2 federal violations of law. Okay. In 2019 and 2020, the government took, and this is a quote from the order, and this is on page 7, modest and, as it turned out, ineffective steps to identify and isolate potentially privileged information contained in the materials seized pursuant to the Richmond warrants. Now let's take a pause here. So what happens is when a search warrant is executed and materials are seized, when there is the potential that there could be privileged information, there is a specific team that is required to review this information. It's a filter team. It reviews the information and materials to call out, to separate out potentially privileged information and materials that was seized during the course of this very expansive search execution. Okay? And these teams, they are not used ultimately because they've been tainted because they've seen privileged information, right? It makes sense. It just makes sense. So this team, this exclusive team, looks at all the materials, identifies potentially privileged information, and calls it and puts it to the side. So ultimately, if the government wants to use that potentially privileged information, it can present it to the court, and the court can decide whether or not it's truly privileged or not. This is to protect not only the government, but to protect the criminal defendant as well. Makes sense, right?
Debt from credit cards is not an accident. It's actually a system designed to keep Americans down. The banks are profiting. The creditors are winning. But who's losing? Oh, the families. Because with every one of those horrible calls, with every fee, with every high interest trap that exists, that's just proof positive that the game is rigged. But people, it doesn't have to be this way. PDS debt has already helped hundreds of thousands of people get out of debt faster. They've helped them cut that debt, end those calls, and get the money back where it belongs, in Americans' pockets and not in the banks. So whether you're struggling with credit cards, with medical debt, with personal loans, PDS debt is here to go beyond just the numbers. They help you craft a unique, personalized plan that is custom to you and your needs. And there's no minimum credit score required. They're just here to help you save more, to cut your debt faster, and to get the money back where it belongs, in your pocket. PDS debt boasts, are you ready? A+ rating with the Better Business Bureau. Thousands of 5-star reviews on Google and a 5-star status review on Trustpilot. Why? Because PDS debt has already helped hundreds of thousands of people get out of debt. If I needed a product like this, I would use PDS debt. So what are you waiting for? Right? It's your money. It's your future. Why are you going to let the system figure it out for you? Just go and get a free assessment. You're less than 30 seconds away from it. Just go and get the free assessment with pdsdebt.com/Phang. That's Phang. pdsdebt.com/Phang. And just in case you didn't get it, pdsdebt.com/Phang. And get that help you need.
The government claims that the documents and communications identified by Columbia University and Daniel Richman as privileged were never reviewed as part of the Arctic Haze investigation. So what does that mean? That means that all of the materials that were seized pursuant to those 4 Richmond warrants, Columbia University made a run at it at first to say this is what is privileged, and also Daniel Richman made a run at it as well. However, who did the government fail to engage? James Comey. The government never engaged James Comey in this process, even though the government knew that Daniel Richman represented James Comey as Comey's attorney as of May 9th of 2017, and 3 of the 4 search warrants authorized the government to search Richman's devices through May 30th, 2017, which was 21 days after an attorney-client relationship had been formed. The government knew this, but they never let James Comey go through it. And you're supposed to do that. You're supposed to let that client of that attorney go through that information to take out what he or she thinks is privileged information. In addition, Daniel Richman's attorney back in April of 2020 tells the government, and by the way, you think the government showed this following letter to the court? No, it had to come from James Comey's criminal defense team. Daniel Richman's attorney, who was representing him during this FBI investigation back in April of 2020, sent a letter to the Department of Justice saying that the data obtained from Richman's iCloud account actually extended as far into August of 2019, outside the scope of the warrant and well past the date that Richman was retained to be James Comey's attorney. That same letter states that the Department of Justice told Daniel Richman that it had seized data from Richman's hard drive that extended to June of 2017, again well into the period within which Richman was representing James Comey, despite the search warrant having a stop date of April 30th of 2017. On page 8, at the time the Richman warrants were executed, the government knew that Richman represented Comey, that he was the ongoing attorney-client relationship with other lawyers, other clients, not only Comey, and the FBI materials also had information that Richman had resigned from the FBI to represent a defendant in a federal criminal prosecution. Knowing all of that, they still went beyond the scope of that search warrant. Of concern is whether the government complied with the fundamental requirement of the Fourth Amendment that can only seize material specifically authorized by the court. In this instance, the government searched all the Richman materials. They were only supposed to seize information related to those two federal violations you and I just talked about: theft and conversion of stolen government property and unlawful gathering or transmission of NDI, national defense information. Those offenses have nothing to do with James Comey's for which he was currently being prosecuted, which deals with false statements, right? There is nothing in the record to suggest that the government made any attempt to identify what documents, communications, or other materials seized from Daniel Richman constituted an evidence of those disclosure of national defense information, right? Now here, the potential failure by the government is even more concerning because the warrant specifically directed the government to identify what information was responsive and instructed law enforcement personnel to seal any information that doesn't fall within the scope of the warrant and to not further review the information absent an order of the court. Do you think the DOJ did that in this instance concerning Comey? It didn't. Page 11, quote, this cavalier attitude towards a basic tenet of the Fourth Amendment and multiple court orders left the government unchecked to rummage through all of the information that was seized from Daniel Richman, and apparently in the government's eyes, to do so again anytime they chose. The Arctic Haze investigation was closed in September 2021 with no charges being filed against Richman. The Richman material sat dormant with the FBI until the summer of 2025 when the Federal Bureau of Investigation chose to rummage through them again. Okay. Now we know that in the summer of 2025, the FBI in the Eastern District of Virginia initiated a criminal investigation into James Comey. An FBI agent reviewed information that had been seized from those Richman warrants. Inexplicably, the government chose not to seek a new warrant for the 2025 Comey search, even though the 2025 investigation was focused on Comey and not Richman, was exploring a fundamentally different legal theory, and was predicated on an entirely different new set of federal criminal offenses. The court recognizes that a failure to seek a new warrant is highly unusual, which is this DOJ under the Trump administration, and that seeking a new warrant would have required a fresh legal analysis and likely resulted in some delay, a delay the investigative team could not afford given that the statute of limitations would expire in a mere 18 days. In other words, because the statute of limitations was going to run on the Comey charges, they decided at the DOJ, being led by Pamela Joe and Lindsay Halligan, to basically say, fuck it to the Fourth Amendment, fuck it to the court orders, but you know what, we want to do this so badly for our dear Führer, Donald Trump, that we're going to say to hell with it and we're just going to go ahead without getting a new warrant. Page 12. Faced with the prospect that any 2025 search would have been different and much narrower in scope than those Daniel Richman warrants, the government chose to unilaterally search materials that were 1. Seized 5 years earlier, 2. Seized in a separate and since closed investigation, 3. That were never reviewed to determine whether the seized information was responsive to those original search warrants, 4. Likely improperly held by the government for a prolonged period of time, and 5. Included potentially privileged information, 6. Did so without ever engaging the privilege holders, as in Comey, and 7. Did so without seeking any new judicial authority. There were no precautions to avoid the collection of privileged communications when it came to James Comey. The agent conducted the review and printed relevant pages that included multiple conversations between Comey and his lawyer, Richman. That first agent then transferred the information to a second FBI agent, who then reviewed those materials and not surprisingly identified potentially privileged materials between Comey and Richman. The government presented its case to the grand jury on September 25th, 2025. That same day, prior to being presented to the grand jury, FBI agent number 2 alerted the lead case agent, who is agent number 3, and an attorney in the Office of General Counsel of the FBI that there was evidence obtained in the government's investigation of James Comey that may constitute attorney-client privilege or attorney-client confidential information. It is also possible that the agents may have obtained evidence that constitutes attorney work product information. Agent 2 gave the Agent 3, and remember, keep this in mind, because Agent 3 is the one who ends up presenting to the grand jury. Agent 2 gives Agent 3 and that FBI attorney a, quote, limited overview of the privileged communications. Agent 3, rather than removing himself from the investigative team until that taint issue was resolved, went into the grand jury undeterred and testified in support of the pending indictment. He was the only witness to testify before the grand jury in support of that Comey indictment. The government's decision to allow an agent who was exposed to potentially privileged information to testify before a grand jury is highly irregular and a radical departure from past DOJ practice. Only after did the government, after all of this shit has happened, only after did the government then seek court approval of a filter protocol for those materials that the FBI had already reviewed. There is no reason provided by the government so far why it waited 31 days, the date from it beginning reviewing the materials on September 12th to September 25th, the date that the FBI informed its Office of General Counsel that it had been exposed to potentially privileged materials, that it failed to seek court approval for a filter protocol. Now, here's where it gets even better, folks. The court reviewed the grand jury transcript, the audio recording, as well as the exhibits presented. Only one witness, Agent 3, testified before the grand jury, and only one prosecutor appeared, and that was Lindsay Halligan. The materials seized from the Richmond warrants were the cornerstone of the government's grand jury presentation. The government substantially relied on the statements involving Comey and Richmond in support of its indictment. Agent 3 referred to these statements in response to multiple questions from the prosecutor and from the grand jurors, and only did so after it had been given an overview of the privileged communications. The government's position that privileged materials were not directly shared with the grand jurors ignores the equally unacceptable prospect that privileged materials were used to shape the government's presentation and therefore improperly informed the grand jurors' deliberations. We're on page 15, people, and it's getting even better. The court has identified two statements by Lindsay Halligan to the grand jurors that on their face appear to be fundamental misstatements of the law that could compromise the integrity of this grand jury process. Both statements were made by the prosecutor in response to questions by grand jurors and are directly related to communications involving James Comey. First, having told the grand jury that she was their legal advisor, Halligan stated, and it's redacted, okay? The prosecutor's statement is a fundamental and highly prejudicial misstatement of the law that suggests to the grand jury that James Comey doesn't have a Fifth Amendment right not to testify at trial. Halligan's statement ignores the foundational rule of law that if Comey exercised his right not to testify, the jury could draw no negative inference from that decision. Halligan's statement may have reasonably set an expectation in the minds of the grand jurors that rather than the government bear the burden to prove that Comey is guilty beyond a reasonable doubt at trial, that the burden shifts to Comey to explain away the government's evidence. Holy shit, people. It is a fundamental premise of the law that there is no requirement that a criminal defendant be forced to testify to explain away the government's evidence. Lindsay Halligan went to law school and ostensibly knows better. But she's so fucking stupid, she made that misstatement of the law to the grand jury. The statement by Halligan was made in response to challenging questions from the grand jurors, the context of which suggesting the grand jurors may have reasonably understood the prosecutor to mean that if Halligan couldn't satisfactorily answer their questions, then Comey would then answer those questions at a jury trial. Are you fucking kidding me? Secondly, Halligan told the grand jury that there was blank. It's redacted. This is on page 16. The statement by Halligan clearly suggested to the grand jury that they didn't have to rely on the record before them to determine probable cause, but could be assured that the government had more evidence, perhaps better evidence, that would be presented at trial. Now here it gets even crazier. As we know, the government presented 2 indictments to the magistrate judge, and the magistrate judge is like, what the hell is going on? Because the grand jury refused to return a true bill on all of the counts in the first one, but Halligan had signed both of these indictments, if you'll remember. The second indictment was actually a new indictment, and therefore the prosecutor would have presented the second indictment to the grand jury right before it was returned in open court. But now this judge says, I don't know if that actually happened. This is on page 17. The short time span between the moment that a prosecutor that was the one who was the first assistant who had been booted out of the job as the U.S. attorney because Pamela Joe thought that Lindsay Halligan should have the job. That prosecutor learned that the grand jury had rejected one of the counts in the original indictment, and then Lindsay Halligan came back to return the second indictment. The judge says it couldn't have been sufficient amount of time to draft the second indictment, sign it, present it to the grand jury, provide legal instructions, and give them an opportunity to deliberate and render a decision on that second indictment. This is great. If the prosecutor is mistaken, as in Halligan, about the time that she got notification of the grand jury's vote on the original indictment and the procedure did take place, then the transcript and the audio recording provided to the court are incomplete. Even though Lindsay Halligan did a sworn declaration that she gave no further presentations to the grand jury other than the one that involved that FBI agent, Agent 3. How is that possible? How do you take a 3-count indictment, jury doesn't return on one of those 3 counts, but then you have a second indictment with 2, and that's the one that indicted James Comey? How do you do those presentations if, according to your sworn declaration, Lindsay, you only presented once? What? The court is an uncharted legal territory in that the indictment returned in open court, indictment 2, was not the same charging document that was presented to and deliberated upon the grand jury. That was indictment number 1. Either way, this unusual series of events, still not fully explained by the prosecutor's declaration, Lindsay's declaration, calls into question the presumption of regularity generally associated with grand jury proceedings and provides another genuine issue the defense may raise to challenge the manner in which the government obtained the indictment. I mean, people, the court is allowed to safeguard the integrity of the grand jury process, and that is exactly what this magistrate judge in the Eastern District of Virginia, Judge Fitzpatrick, is doing. I invite you to read this 24-page order. I know I went a little bit long in today's episode, but people, grand jury records are not turned over to criminal defendants all the time. This is so rare. And when a judge makes 24-page findings of the fact that the 4th Amendment and the 5th Amendment and the grand jury and the rules, all of these things were being violated by Lindsay Halligan and the FBI agents, why? To go after James Comey? Because Donald Trump wants to go after his political enemies? No American should stand for the proposition that we can violate the Constitution when we want to just because we don't like people. This is not our America. And Judge Fitzpatrick is saying this shit ain't going to stand on my watch. Now, this can be reviewed by the presiding judge, Judge Nachmanoff. But let me tell you something. With this level of detail and factual findings by the magistrate judge, Judge Fitzpatrick, I'm going to tell you right now, those grand jury materials are going to be turned over wholesale in their entirety to James Comey's criminal defense team. And I would not be surprised if this case gets dismissed. Be mad, be outraged, demand accountability. Let's go rattle some cages, people. Share this episode, please, to people so they understand how the weaponization of our Department of Justice is being grotesquely done by Trump and this DOJ. Please. And as a side note, if you are a subscriber, I thank you. If you're not, subscribe so you can watch this. Folks, I'm trying to get to 500,000 subscribers by the end of 2025. We're so close. We're at 430. I appreciate your support always.
Hey folks, it's the last day of 2025. I don't know about you. I do New Year's resolutions, and I hope that you're working on yours. And one of them is to provide more content here at the Katie Phang News Channel. So if you haven't subscribed, like and subscribe and let others know if you enjoy the content. What I wanted to cover with you is something that you've seen in the news since yesterday, but I wanted to break down that court order with you. It is the recently unsealed order from a judge, a federal judge in Tennessee, in Kilmar Abrego Garcia's criminal case. As a reminder, Kilmar has two parallel cases that are currently going on. He's being prosecuted in a bullshit prosecution by the Pamela Joe DOJ for alleged human smuggling and trafficking. And that case was brought in Tennessee. But he also filed his own federal case, a habeas corpus case, concerning whether or not he can be deported again out of the United States. Kilmar Abrego Garcia, one of the many individuals that were illegally and unconstitutionally cheated of their due process, removed from United States soil, taken to CCOT, that terror confinement facility in El Salvador that was in violation of an order that was entered years ago in Kilmar's case that said he was not supposed to be deported to El Salvador. He actually was going through the legal processes to stay in the United States. And so it's important when we highlight these orders that are coming from federal judges because, number one, they're following the law. They're defending the rule of law. And number two, in this particular order, we see that Kilmar's motion to dismiss his criminal case because of vindictive prosecution by the Trump government. Well, we knew it was well taken, but now we're seeing that there's actually evidence that corroborates and supports his position. So let's go through this order together so that we understand all of the issues. Alrighty, so we have this order that was entered by a federal judge, Judge Crenshaw, in the Middle District of Tennessee, Nashville Division. It's entitled Memorandum, Opinion, and Order, and this was, again, previously sealed, and so the public wasn't able to access this information until it was unsealed late yesterday. So the judge in this case, Crenshaw, says that there's two pending motions. One, Kilmar's motion to dismiss for vindictiveness and selective prosecution. And two, the federal government's, the DOJ's motion to quash subpoenas for DOJ officials Todd Blanche, the Deputy Attorney General of the United States, Akash Singh, and James McHenry. They are also DOJ employees. Kilmar Abrego Garcia's lawyers have basically subpoenaed those three individuals to begin with to be able to sit for depositions and to be able to provide documents and information as a part of what we call the discovery process, the production and the provision of information either through sworn testimony and depositions or through production of documents and answers to written questions. And so in this instance, in order to prove up his claim of vindictive and selective prosecution, Kilmar needs the evidence. It's really hard, as a footnote, when you are a criminal defendant who's attempting to prove vindictive and selective prosecution, because the burden is on you to prove it, and yet how do you prove it if you don't get the access to maybe the internal documents and communications that would prove up or evidence what you're suggesting or what you're claiming? And so it's a little bit of a catch-22. So you can imagine if a federal judge has found that Kilmar has pretty much met that burden to be able to even get the discovery in his case, that things must be pretty bad for the Trump DOJ. So what the government is doing here is they've also filed a motion to say we want to quash those subpoenas to Blanche, Singh, and McHenry, that they would have to testify at an evidentiary hearing on Kilmar's motion to dismiss. Let me also note for you, evidentiary hearings are incredibly powerful. They are what they sound like. It is a hearing that is run by the court. There's no jury present, but the people who testify, they testify under oath, under penalties of perjury. They are subject to cross-examination by opposing counsel. And during the course of an evidentiary hearing, you actually have things entered into evidence versus just arguments that are made by lawyers. And so evidentiary hearings are incredibly powerful. And the fact that Kilmar Abrego Garcia is allowed to even have one, again, is a big win for him. In this instance, Judge Crenshaw indicates in the order that the court reviewed in camera. That means in chambers. That means that the government produced over 3,000 documents for purposes of review by the judge and the judge only.
That was for the judge to be able to look through the documents before they are produced to the other side. Why? Because the government in this case said that there were various privileges that would protect the production of these documents to lawyers for Kilmar. And so the judge looked at these over 3,000 documents in camera, in chambers. That's Latin for in chambers, right? And after reviewing these 3,000 documents, the court found that it's going to grant, in part, Kilmar Abrego Garcia's motion to compel discovery and require the DOJ to disclose to his lawyers a subset, meaning some of those over 3,000 documents that are relevant to the narrow issue of whether the DOJ's new decision to prosecute Kilmar Abrego Garcia after they initially decided never to prosecute him, but instead to do what? To ship him off to CCOT, right? The judge says, you know, some of these documents are relevant to that particular narrow issue. And it's because Kilmar has argued that the decision to prosecute him criminally in Tennessee was, quote, tainted by improper motivation. What was that improper motivation? Because Trump and the DOJ was embarrassed that Kilmar had success in his habeas corpus immigration case in Maryland, and because they had mud and egg on their face and they looked like shit, frankly, in front of the American public, that's the reason why they decided to vindictively criminally prosecute Kilmar Abrego Garcia. Now, the judge also denied in part some of Abrego Garcia's motion to compel discovery and said, look, I want further briefing. I want further legal documents filed setting forth your arguments for and against why Blanche, Singh, and McHenry should have to testify at these evidentiary hearing, and it's after you consider the documents that are produced. And so in other words, what the judge is saying is, hey, Kilmar's lawyers, I'm going to give you a subset of these over 3,000 documents. Once you've received them immediately, because that's what the order says, that you have to be turned over immediately, we're then going to allow for further legal briefing done, and then I will decide as the court whether these people must testify at the evidentiary hearing. So there's a process. It's a multi-step process, but there's a process. So the order in this instance is a 9-page order. You see it on your screen right now. And the judge very smartly calls out the DOJ and says, the government produced over 1,000 documents, many of which are hundreds of pages of duplicative copies of Kilmar's immigration file, as well as internal communications among investigators, attorneys, and others that have no relevance to Kilmar's motion to dismiss. In other words, it was a huge document dump that they did to the judge of all people. But the judge says, still, having reviewed all of the documents provided by the government, the court finds that some of these documents are relevant to Kilmar's motion to dismiss. They must be produced to him under a protective order, which means we, as the American public, don't get to see those documents, and only the lawyers for Kilmar get to see them. The court meticulously goes through the relevant dates in the timeline of Kilmar Abrego Garcia's prosecution and notes that when he was initially pulled over for speeding in November of 2022, they didn't give him a ticket, they being Tennessee Highway Patrol, didn't give him a ticket, didn't arrest him, let him go his way. Now, Tennessee Highway Patrol, if you will recall, did make a referral to Homeland Security based upon a suspicion of human trafficking back in 2022. But then let's fast forward 3 years to 2025, because that's when the Bondi DOJ said, we're going to deport Abrego Garcia to El Salvador without ever bringing criminal charges against him, right? So they deport him to CCOT. He then successfully challenges his deportation to El Salvador. And then suddenly the Department of Justice finds Jesus and decides that they want to now prosecute him for alleged human trafficking, right? Because he was never charged with that or any other crime until he successfully won his federal district court claim. It was upheld by an appellate court, and the United States Supreme Court said that the Trump administration had to facilitate his return from CCOT. But I know I don't have to remind you that Trump, remember Bukele, the president of El Salvador, and you had J.D. Vance, Marco Rubio, and all those other dumbasses swearing in the Oval Office they'll never bring him back. Kristi Noem, Pam Bondi, all swearing up and down, on the Bible, never going to come back. We're never either going to be able to bring him back, we cannot do it, we won't do it, he'll never be back. And then suddenly, when they're embarrassed, they're able to
find him and bring him back? That's why he's brought this motion to dismiss. Now, the cornerstone of his motion to dismiss, according to the court, is that the decision to prosecute him was in retaliation for his success in the Maryland District Court, which is why when the judge walks through the timeline and the dates, you see it's pretty obvious and blatant on its face that the DOJ was just motivated by wanting to punish him. I mean, if there really was anybody who has been the subject of absurd and grotesque persecution, not just prosecution, it's Kilmer Abrego Garcia. Kilmer relies upon statements made by Todd Blanche in the media, claiming that the primary kind of thing that they're trying to do is go after him. I mean, he was dumb enough to say that. Nevertheless, and despite Blanche's remarks to the media publicly, the DOJ says it didn't decide to prosecute him in retaliation. It was actually the acting U.S. attorney in Tennessee that made this decision. But the judge notes the following in the order. The judge notes that there's actually things like emails and communications internally that show that Akash Singh decided to tell the U.S. attorney in Tennessee, listen, we want to make sure that you know that his criminal prosecution is a, quote, top priority for Todd Blanche, that Blanche would like Garcia charged sooner rather than later. If Blanche wants to move forward with the indictment, it's prudent to loop in the press office ASAP. Closely hold that draft indictment until you get clearance to file. I mean, these are the types of commands, orders, and directives that are being provided to the U.S. attorney. From whom? From Todd Blanche by way of Akash Singh and others. Now, the court says in the order, I recognize that there are certain privileges that exist that the government has asserted to protect the production of these documents to Kilmer Abrego Garcia's lawyers. But the court notes, quote, Abrego's due process right to a non-vindictive prosecution outweighs the blanket evidentiary privileges that are asserted by the government, end quote. Then it goes on to say, if the work product, attorney-client, and deliberative process privileges asserted by the government precluded all discovery in the context of a vindictiveness motion, defendants would never be able to answer the question, what motivated the government's prosecution, end quote. Makes sense. It's what we just talked about a few minutes ago. If I, as a criminal defendant, can't actually access the evidence to show that there was a vindictive intent behind bringing this prosecution in the first instance, then I'll never be able to succeed on a motion to dismiss. So the court concludes, beginning on page 8, that the government shall immediately produce these documents to Abrego pursuant to a protective order, and supplemental briefing on whether or not those those subpoenas should be quashed as the federal government is asking to happen. Here's the following dates: December 12th, December 19th, and December 23rd, all of which have come and gone. And so we're going to see whether or not actually those, that testimony is going to end up to move forward. And at this point, you got to hand credit to Judge Waverly Crenshaw, United States District Court judge in Tennessee. That judge also allowed Kilmer Abrego Garcia to be released on pretrial release, saying that he was not posing a risk of threat to the community and to the safety of the community while his criminal case is pending. And we also acknowledge that Judge Paulazinas up in Maryland said that he could not be deported again while his case is pending. These are all important rulings from federal judges that are holding the line in the defense of democracy. And as I always say here at this channel, we have to give them credit where credit is due. Be mad, be outraged, demand accountability. You know that we're going to up the ante in 2026. There's so much at stake, but we're in this fight together.
Bombshell. New evidence has been provided to the Senate Judiciary Committee regarding Emile Beauvais' nomination to the Third Circuit Court of Appeals. Who has provided this additional information? The original whistleblower, Erez Raveni, who we've covered here at the Katie Phang News channel before. As you will recall, the day before Beauvais' original testimony, sworn testimony provided to Congress in support of his confirmation, this whistleblower, Mr. Raveni, came forward with receipts emails, text messages, and other communications that corroborated his position that Emile Beauvais not only said that he would say fuck you to the courts when the courts told him to do something, and by the way, folks, I know I curse, but that fuck you was an Emile Beauvais one. In addition, Emile Beauvais has his DNA and fingerprints all over criminal contempt of court, because he had been instructing people within the Department of Justice and related federal agencies to ignore a federal court order. After Beauvais testified, wherein he lied according to this whistleblower, Beauvais lied to Congress in his confirmation hearing when he denied that he ever said fuck you, one, and two, when he denied that he would ever be complicit in what was happening with these flights of people in violation of a federal judge's order. So, you know what Ravini said? Fine. I see your lies, Emile Beauvais, and I raise you the truth. And so what has Mr. Ravini done? He's produced more evidence. So let's walk through this. If you are not following justsecurity.org, go there now. The work they are doing there is impeccable. They are covering everything that is important right now. Very, very, very much so in the legal space, especially. You gotta go. So Tom Jocelyn is a part of Democracy Defenders. I know. Full disclosure always, I am a part of the Democracy Defenders organization. And Ryan Goodman, who's just a spectacular, spectacular person that you should be following as well. They just published today the documents implicating Emile Beauvais in criminal contempt pursuant to the order that Chief Judge James Boasberg in D.C. has entered. Okay, so let's go back to square one and let's kind of tie this together, right? So the Senate Judiciary Committee is due to vote on Emile Beauvais' nomination on July 17th. Back in April, sounds like it was forever ago, feels like it sometimes, April of 2025, Chief Judge James Boasberg entered an order stating that there was probable cause that the Trump administration engaged in criminal contempt, having, quote, willfully disobeyed a binding judicial decree, end quote. We've talked about James Boasberg here. We've talked about Judge Paula Zinnes. We've now talked about other federal judges that have just had it. They're just fed up. They're fed up with the misrepresentations, the lies, the dishonesty, the non-compliance, and they're like, you know what? Not on my watch. So Judge Boasberg was one of the original judges that was like, look, I entered an order, you disobeyed, let's roll. So back in April, he enters this order finding that the Trump administration officials basically violated a court order and that they should be held in contempt. Now, the whistleblower, as I mentioned, is Mr. Erez Ravini, a 15-year DOJ lawyer who was dismissed from his job after he refused to do what he was being ordered to do by his supervisors at the Department of Justice, a talented, respected immigration attorney at the Department of Justice for more than 15 years. But he's the one who told the judge that Kilmar Abrego Garcia was mistakenly deported. It was an administrative error. And then he got in trouble. And then when he refused to basically, do what his supervisors was telling him to do, then he got dismissed. So Ravini, dismissed in April, provided documents to the Senate committee prior to Beauvais' testimony. But then, just yesterday, newly released text messages reveal that Beauvais did tell his subordinates to basically say, fuck you, to the courts when the judges told them to stop doing the illegal and unconstitutional deportations. These text messages are between Ravini and his colleagues, including his direct supervisor, August Flente. And in addition, other emails and text messages reveal that Emile Beauvais was directly involved in the Trump administration's decision to defy Judge Boasberg's order demanding that the Alien Enemies Act deportees be returned to United States soil. So what does that mean? That means that Beauvais not only disregarded the court order from Boasberg to bring them back to the United States, those deportees that were sent pursuant to the Alien Enemies Act, but Beauvais has also directly violated the due process rights of those people. Finally,
This new trove of documents that have been provided yesterday also reveal that Bove lied during his Senate confirmation testimony. If that isn't enough to be able to completely disqualify him from serving as a federal appeals court judge, I don't know what else it's going to take. I know it takes a lot to shock the conscience. I also know it takes a lot for Senate Republicans to do the right thing, as we've seen them fail time and time again. But this is somebody who's going to be sitting as a federal appeals court judge. So at a minimum, his veracity should be unimpeachable. But we've seen worse, right? Okay, so let's go back again. So Judge Boasberg ordered on March 15th that the Trump administration must return the Venezuelans that were deported illegally and unconstitutionally pursuant to Trump's BS executive order of the Alien Entities Act, that they must be returned to United States soil even if the planes carrying those deportees had already landed in El Salvador. Boasberg said, do not let them be deplaned. They must immediately be turned around on those planes and returned to United States soil. In no uncertain terms, should those deportees be deplaned or disembarked, even if they have reached El Salvador, the judge's order was clear. The court transcript is clear. That is what Boasberg ordered. Now remember, this is a March 15th order from Boasberg. A March 16th email from Yakov Roth, the acting head of the Department of Justice's Civil Division, is sent to Riavini and other DOJ officials. Within that email, Mr. Roth says, I have been told by the Office of the Director of Attorney General that the Principal Associate Deputy Attorney General advised DHS last night that the deplaning of the flights that had departed U.S. airspace prior to the court's minute order was permissible under the law and the court's order. What? What? And who is that Principal Associate Deputy Attorney General? That was Emil Bovee. Okay, listen. We didn't go back in the hot tub time machine, did we, Emil Bovee? March 15th, Judge Boasberg says, these people must be returned immediately. Do not let them be deplaned or disembarked. Bring them back to U.S. soil. That's March 15th. On March 16th, you have the guy who's heading up the civil division at the DOJ saying that Emil Bovee has now ordered and advised legally to the Department of Homeland Security that it's okay for those deportees to be remaining in El Salvador. Okay, so that's one email that has now been newly released that shows that Bovee not only defied Judge Boasberg's order, but was sitting there being complicit and violating the due process rights of those deportees. Now, you got to look through this treasure trove of documents. Again, go to justsecurity.org so you can see what's in there. But there's email upon email wherein Mr. Riavini makes it clear that he is concerned that they will be held in contempt of court because Judge Boasberg's order was so crystal clear on its face on what was supposed to happen. And he keeps on warning. Riavini keeps on saying, people, we gotta be in compliance. We have to be in compliance with what Judge Boasberg said. As the series of Riavini's emails make clear, the DOJ attorneys fully understood that Boasberg had ordered the return of all AEA, Alien Enemies Act, deportees, and that they should not be deplaned in El Salvador. Okay? He made it clear. He worked in that DOJ, right? Riavini made it clear what was going on. So on April 16th, a month later, Judge Boasberg ruled that there was probable cause to hold the Trump administration officials in contempt, criminal contempt, for violating his temporary restraining order. This is what Boasberg wrote, quote, the court ultimately determines that the government's actions on that day, March 15th, demonstrate a willful disregard for its order, sufficient for the court to conclude that probable cause exists to find the government in criminal contempt. The court does not reach such conclusion lightly or hastily. Indeed, it has given defendants ample opportunity to rectify or explain their actions. None of their responses has been satisfactory. Damn, you don't want to be on the receiving end of an order like that. At least if you're a lawyer who has decency and professional, responsibility and morals and ethical conduct, you don't want to be on the receiving end of that. Boasberg set forth a two-step process. First, before initiating any criminal contempt proceedings, courts typically allow the contumacious party an opportunity to purge its contempt. Contumacious meaning what? The party that is committing the contempt. In your willful, contumacious disregard of a court order, meaning your willful, intentional, contemptuous disregard for that order. The most obvious way for defendants to do so here is by asserting custody of the individuals who were removed in violation of the court's class-wide TRO, temporary restraining order, so that they may avail themselves of their right to challenge their removability through a habeas proceeding. Now remember, the United States Supreme Court, 9-0, held that pursuant to this Alien Enemies Act deportation scheme, that these detainees are entitled to notice and an opportunity to be heard, that they are entitled to their due process. So Boasberg's just saying, look, you want to cure your contempt? Trump DOJ? Trump administration? Bring them back so that they can actually assert a habeas corpus petition. We've talked about that here a lot, right? They can assert habeas corpus and they can actually get their due process. And listen, at the end of the due process, if they end up getting deported, okay. But they still get their process. That's what we've been calling for since the beginning. Should the Trump administration choose not to purge its contempt, Boasberg said, then the court will proceed to identify the individuals responsible for the contumacious conduct by determining whose specific act or omission caused the noncompliance. After determining the responsible individuals, the court would then request that the contempt be prosecuted by an attorney for the government. Now here's the wrinkle, but Boasberg was anticipating it because he's a smart judge. Should the government decline, then the interest of justice requires the court will appoint another attorney to prosecute the contempt. End quote. Boasberg knows. He knows. He's got these people in the Trump administration dead to rights. He knows that they are not going to continue to comply. So he said, fine, you don't want to prosecute pursuant to my contempt findings? I'll find a lawyer who will. Before Boasberg actually got to initiate that contempt process formally, the government appealed and the Court of Appeals granted an administrative stay while the issue was on appeal. Look, of course, if these contempt proceedings get to move forward, these emails and text messages are going to be huge in the finding by Judge Boasberg that Emile Beauvais himself was complicit in this criminal contempt. Now let's quickly go through the rest of what was revealed yesterday by the whistleblower, Mr. Ravani. During his nomination hearing, Senator Adam Schiff asked Emile Beauvais, did you suggest, as Mr. Ravani wrote, that DOJ would need to consider telling the courts fuck you and ignore any such court order? Beauvais answered to Senator Schiff, I did not suggest that there would be any need to consider ignoring court orders. He then went on to say, Beauvais, I will reiterate, I did not advise any Justice Department attorney to violate court orders. And yet we now know that several of the emails that have been provided corroborate Mr. Ravani's statements as a whistleblower, that is exactly what Emile Beauvais said. Emile Beauvais told his subordinates and people in that meeting on March 14th at the Department of Justice, if the judges tell you that they cannot, that the Department of Justice cannot do what it wants to do pursuant to the Trump administration's immigration policies, Beauvais said, tell the courts fuck you. And how do we know? I mean, look, you yourself can check out these emails. These emails make it perfectly clear that that's exactly what happened. These emails are stating, hey, this doesn't end with anything but a nationwide injunction and a decision point on fuck you. In response, one of Ravani's colleagues says it's a question if Drew gets out with a sanction. Drew Ensign, one of the lawyers from DOJ who's been arguing this stuff, right? Furthermore, Ravani, notifying his colleagues in real time of Boasberg's temporary restraining order ruling, immediately texted his supervisor, Flinte, with an apparent reference to the fuck you statement by Beauvais. Guess it's find out time on the fuck you. Yup, it was good working with you. The first El Salvador flight lands in an hour, so says flight aware. Later that evening at 8:16 p.m., after Ravani says he reviewed public information showing 2 flights had landed in Honduras, Ravani texted a colleague with another reference to the fuck you comment. Guess we are going to say fuck you to the court. Super. Answer, well, Pamela Jo Bondi is, not you. Beauvais lied when he denied that he said it. What's Beauvais going to do now? Say, I didn't say it. Fuck you was said in that meeting, but it wasn't me. It was someone else. Please, don't insult our intelligence. I urge you to go and review at justsecurity.org Tom Jocelyn and Ryan Goodman's piece from today. It just underscores the reality, which is there is such a level of contumacious disrespect, willful and intentional, contumacious disrespect and conduct that's being exhibited by this administration. For those of us that have been raised like proper lawyers and not are heathens in the judicial system, this is not how you operate. Again, if you do not like a ruling, you appeal it. And then you continue to appeal whatever happens at that level, right? Until you get to the end of that process. We all have to live and die by the law. We cannot selectively choose to do what we want to do. It is the true constitutional crisis when you find that the executive branch is giving the literal middle finger, a la the phrase, fuck you, to the judiciary. It is galling to think that then that person who gave the middle finger, who is then ordering his subordinates to do it, thereby putting pressure on subordinates to have to obey a supervisor or risk what? Exactly what happened to whistleblower Arez Rovene. You get fired, you get dismissed, you get investigated, maybe even prosecuted by this DOJ. How horrific is it to think that that person, Emil Bovee, could be sitting on the Third Circuit Court of Appeals, a lifetime appointment as a federal appeals court judge? Why would you want to do that, Emil Bovee, if you have such disrespect for your colleagues, for your brethren on the bench? You don't have respect for Chief Judge James Boasberg, and he's going to be somebody that is technically your colleague as a judge. What are you going to do if you don't agree with your colleagues at the Third Circuit Court of Appeals? When you're sitting on a panel with them and you don't agree, are you going to turn to them and say, fuck you? It is maddening. And it is just outrageous that I find myself making videos where I have to talk about it repeatedly, that there is a lack of compliance, that there is such a lack of respect in this system. Man, let me tell you something. I've said this a long time ago when I started this channel. I will say it again. These judges that are being disrespected and disobeyed, they need to grow a pair, even bigger, and they need to have some teeth on these sanctions. Sanctions is the way to do this. It's the only way that they're going to listen. Be mad, be outraged, demand accountability. Again, go check out justsecurity.org. Tom Jocelyn, fantastic guy. Ryan Goodman, fantastic guy. They are doing some good and important work. I'll see you on the